Okay, so let me start. So welcome to you all. We are very pleased to welcome you for this first edition of our new Zoom-in series of hopefully monthly webinars on transnational sports law that I have the pleasure to co-host and organize with Marjolaine Viret. So I am Antoine Duval. I'm a senior researcher at the IAAF Institute in The Hague and the head of our International Sports Law Center. The center, as some of you will already know, is the home of the International Sports Law Journal, the IAAF Press International Sports Law book series, and the conveyor of a variety of conferences and events on transnational sports law. So this new series will focus not only, but a lot on recent awards and decisions. And we plan on inviting a wide spectrum of speakers, also from various disciplinary horizons, as reflected already today, to engage in the key issues that are raised by the latest transnational sports law decisions. So today, as you all know, we start by discussing the Blake Leeper Award that was rendered on 23rd October by the Court of Arbitration for Sports. This is 12 years after another famous decision of the CAS, the Pistorius Award, on which our speakers will certainly come back. That touches as well on the question of the right of disabled athletes to compete with running specific prosthesis in IAAF competitions, and obviously also in particular at the Olympic Games. And in a way, this question is back, and it's back with a vengeance, both for the readers in terms of the length of the award. So where the Pistorius Award was 14 pages long, the Blake Leeper Award is 109 pages long. So this is obviously a considerable inflation, part of a wider trend in terms of the lengthiness of CAS awards that I think is worth noticing and as well reflecting on maybe. And as well comes back with a vengeance for the athlete and the claimant, because where Pistorius prevailed, Blake Leeper failed in front of the CAS. He was in a way defeated by this award. And we are going to discuss whether this is an actual defeat or just an apparent one. This might be up for discussion. There are many interesting aspects of the decisions that we will touch upon today. I think there are questions that are linked to who bears the burden of proving the existence or inexistence of an unfair advantage when using those prostheses. There are questions related to the assessment of scientific evidence put before the CAS. And there is the broader question of the long-term impact of this decision beyond this particular case, basically. So without further ado, let me turn to introducing our three speakers, starting with my co-host, Marjolaine Viret, who will also act as a speaker today, and will briefly, in 5-10 minutes, walk us through the key aspects of the award. And so Marjolaine, for those of you who don't know her, she's a researcher and a practicing attorney in Geneva, working at the intersection between science, health law, and sports law. We had the privilege of publishing her book on evidence in anti-doping at the intersection of science and law, which I think is a crucial read if you want to grasp the intricate nature of science and law in the sporting context, and in particular in the doping context for that book. The second speaker will be Professor Wolfgang Potthast, who is a professor of clinical biomechanics at the Institute for Biomechanics and Orthopedy at the German Sport University in Cologne. He has researched and widely published on the use of prostheses in the sporting context, and in particular for running purposes. And Wolfgang was also involved as an expert, I think, during the Pistorius hearing at the CAS 12 years ago. So it's interesting to hear you about that experience of being a scientist in the middle of a CAS hearing. And our third speaker will be Professor Roger Pilke, a junior from Boulder University in Colorado. So Rogers has been publishing and working on issues of sports governance in the later years, and in particular on the use as well of scientific evidence in the sporting context. Roger is the author of The Edge: The War Against Cheating and Corruption in the Cutthroat World of Elite Sports, and was directly involved as well as an expert witness in another important case, and maybe we might want to make some links with that case, that pitched an athlete against the IAAF, the Semenya case. So that's as well something that we might want to reflect upon, how those two cases work together. So after the three presentations of around 10 minutes, we will have time for a Q&A. You are invited to share your questions via our chat box at the bottom of the screen. But now let me leave the floor, the Zoom floor, and give it to Marjolaine. Marjolaine?
Yes, so thank you, Antoine. So as you said, I'm really thrilled too about this launch, and I'm thrilled to hear more than all from our two guests today. I think we have a first team for this first session, which goes far beyond issues of law, and it should really give us the opportunity to spark a debate around some fundamentals in competitive sport, and then hopefully engage our audience that we'll hear from in the chat. So we would also like to put everyone in the audience on some equal or at least some common footing. So let's look first at what the CAS Award actually tells us. And as Antoine said, well, it's tough to give a 5-minute overview of a 110 page award, but I'll have a try. And I'd like to start saying this: there are really two sides to the award. So the general abstract considerations regarding the validity of the regulation, and then the application of the regulation to the case of Leeper. Mr. Blake Leeper, he's a bilateral amputee track runner specializing in 400 meter, and he applied to the IAAF, so now World Athletics, to obtain a decision that his prostheses were allowable as mechanical aids to compete at IAAF events. So he went through a process and various tests, but his file was finally rejected by the IAAF on the ground that he had not demonstrated that his prosthesis did not give him an overall advantage over his opponents. And so for some background, which Antoine already gave in part, the entire case relies on a rule introduced by the IAAF that declares, in particular, assistance through mechanical aid prohibited if it confers an overall advantage to the athlete using it. And historically, this rule came first before CAS in 2008 with the runner Oscar Pistorius, who is also a bilateral amputee, who applied for a similar authorization and who was equally denied authorization. And at the time, it was common ground among the parties before CAS that the burden of proof was on the IAAF to show the overall advantage. And it was then Wolfgang Potta's group who conducted the studies on Oscar Pistorius. And then in short, the panel found that the evidence was inconclusive on the overall balance of advantage and disadvantage. So Pistorius had to be admitted for participation. And then the IAAF amended its rules to provide explicitly that the burden of proof was now on the athlete to show an absence of overall advantage from the mechanical aids. And so this prevented in particular the long jumper Markus Rehm in Germany from being admitted to seeking qualifications for the Olympic Games. And again, the evidence was inconclusive for Markus Rehm. Only that the situation had now changed because the burden of proof was now on the athlete, and Markus Rehm had failed to discharge his burden, so he had to be excluded from competition. Markus Rehm never went to CAS, so this rule in this amended form was for the first time with Blake Leeper submitted to the scrutiny of the CAS. So now to start with the abstract part of the assessment of the validity of the regulations, the CAS looked at the matter from a perspective of discrimination. So they accepted that there was a discrimination on the ground of disability, but then they consider whether the rule was objectively justifiable when it comes specifically to placing the burden of proof on the disabled athlete. And the panel reached the conclusion that it was not. So they had to reword the rule in order to shift back the burden to the IAAF. So in effect, brings us back to the situation that prevailed in the Oscar Pistorius matter. And they did so in particular, first for reasons of principles, because the rule was asking the athlete to prove a negative, and then second, for practical reasons. The arbitrators found it was unreasonable to expect athletes to bring up the resources to invest in experts and studies to discharge their burden. Then it's also important to say a word about what the CAS defined as the test for overall advantage. So with the obvious follow-up questions, which is advantage over whom or what? And here the panel found that you have to use as a comparison the hypothetical self of the athlete without his disability. So in the case of Mr. Leeper, if he had biological legs. And then the panel, so that's the first, the second part, the panel proceeded to assess Mr. Leeper's situation and the studies performed. In particular by Professor Grabowski at the Boulder University in Colorado. And in short, the panel found that the conclusions drawn from the test conducted on Leeper did not allow for the conclusions that they had drawn. And then they focused on one specificity of Mr. Leeper, which is that he chose to run with prosthesis that make him run much taller than what is allowed under the so-called MASH rule. The MASH rule is the maximum allowable standing height, and it's a formula to calculate the maximum height at which an athlete is allowed to run in Paralympics. And here Mr. Leeper was substantially, as in the panel found, around 15 centimeters taller than that. And then second, the panel accepted that there is a direct relationship between running height and running speed. And so because Mr. Leeper was running much taller than he would ever have been with his biological legs, necessarily his prosthesis were giving him an advantage. So the panel concluded that the IAAF had discharged its burden and that Mr. Leeper could not compete, or at least not with this current prosthesis. So that's a very rough summary of the award. Now, I'd like to initiate maybe the discussion with some thoughts. And first, as the Pistorius and the REM case showed, it's clear that in many situations, the science is likely to be simply inconclusive. And then obviously the burden of proof becomes decisive for the outcome of disputes because it gives a rule of decision to panels on what to do in the face of this uncertainty. And Roger, I think this is a common cause that we have that to try and show how far the science can bring us and where we have to accept that we are dealing with societal, cultural, moral, ideological choices. And you've said it before in The Edge that Antoine mentioned, and you said it again recently in a blog about the Leeper case, and I quote, how we act in the face of irreducible uncertainties reveals our underlying values. For the IAAF, where the burden of proof resides reveals whether the institutional default is exclusion or inclusion. So here it means that the CAS has decided, or let's say forces the IAAF to err in doubt by default on the side of inclusiveness of the disabled athlete, which is a real policy choice. And the same with, I think, Wolfgang, in one paper you co-authored with Brendan Burkett and Michael McNamee regarding the case of Oscar Pistorius. You describe this as a boundary or line drawing problem, which can only be solved through both empirical data and ethical debate. And then to the test that the CAS panel declared decisive to decide whether there is this overall advantage. To non-scientists, it seems that there are many unknowns about this test on how best to apply this test if you use as a comparison the disabled fictional self of the athlete without the disability and not some other able-bodied athlete. So it might prove difficult in many situations to actually design empirical studies, and maybe even conceptually impossible, because it's impossible to have a real-life control that you use for the study. And finally, in addition, well, Wolfgang will correct me if I'm wrong, but in the papers I saw from you regarding both running and long jump with prosthesis, in many respects, actually, the science will find that the biomechanics of the disabled athletes with the mechanical aid just operates differently from the human body without such aid. So comparisons are also difficult already for this reason. And finally, in this regard, no scientific study can tell us whether these differences should be considered so different that they no longer qualify as something that is a comparable act of performance. So no longer qualified for the constitutive elements of the sports discipline. And so the cases really raise broader issues around what we consider natural or artificial in sport, and they force us to question this ideal of equal opportunities of sports competition. So it's really a question of how we frame the debate. And I'd like to end, before I hand over to Wolfgang, I'd like to end with a quote from your paper, Wolfgang, which I thought was quite provocative and inspiring at the same time. So it was about Oscar Pistorius. And you say, without making positive or negative ad hominem remarks, Oscar Pistorius might be viewed as an athlete attempting to achieve his potential at the 400-meter sprint, a vanguard figure challenging the deficit model of disability, someone whose performative self challenges the borders of human identity and technology, a sub-elite athlete attempting to break into the lucrative world of elite commercialized sports via technological assistance, or an athlete using unfair means to compete at the Olympics. These options are not exclusive. And I think with this, we can pass on to our two guests and get your statements on the case. So Wolfgang.
Hello, everybody. Good afternoon from Europe. Good morning, probably, to the Americas. And I don't know, good night in Asia or something like that. I don't know exactly. Thank you very much for giving me the opportunity to discuss this, well, this evergreen in sports science, so to speak, which is about many different things. It's about biomechanics, it's about movement science, and it's about politics and philosophy. In my view, the decision of the CAS is correct, or is right, that Blake Leeper, under the given circumstances, is not allowed to compete at the Olympic Games on the same scoreboard as athletes without physical impairment or not using prostheses. I mean, it's common sense that an artificial extension of leg length would increase running speed. And even the data provided by the group of Toboga and Grabowski, which have been reanalyzed by the group of experts for the CAS hearing from Sean Tweedy and Mark Koenig and so on, who did, from my point of view, a very, very good job in that. They very clearly show that actually in 4 out of the 5 subjects, the running speed increased with longer legs or with longer prostheses. So therefore, I think it's quite clear that an artificial extension of the leg would have the potential to increase running speed. And very naively asked, why is Blake Leeper using that long prostheses if they don't make him faster, or if shorter ones wouldn't make him slower? Then he could at least participate in the Paralympics, which he doesn't, because he's using longer prostheses which violate the maximum allowable standing height. But dealing with athletics on prosthesis for about 15 years now, I think there's a much more important discussion. I think more important than the discussion about fairness and unfairness and about advantage or disadvantage is the question, what do we want to compare in athletic competitions? And the decision if Blake Leeper or Oscar Pistorius or Markus Rehm should be allowed in the Olympic Games, I think cannot be answered just by biomechanics, you mentioned that, or by movement science. It has to be answered by governing bodies, and I think they didn't do such a good job the last 15 years. It has to be answered by politicians, philosophers, and maybe by lawyers. So we as scientists, as movement scientists, as biomechanists, we can provide facts. We try to provide understanding, relationships, mechanisms. Maybe we can say here's an advantage or there's a disadvantage. And this, for example, shows that running without prosthesis, this understanding that running without prosthesis or jumping with and without prosthesis are based on very different movement principles, physical different principles. Energy storage and return, for example, is much more important in prosthetic running and jumping than running and jumping on biological legs. It's a completely different physical principle which is applied. And therefore we say that running or jumping on a prosthesis and running or jumping on a biological leg are two different disciplines, maybe the same sports, but different disciplines. So those kinds of understanding, that's what science can provide. And the question, what do we do with that? How do we deal with this understanding? That's a question for governing bodies, politicians, and jurisdiction. Of course, we have to do that interdisciplinary. We have to discuss that. And as I said, I think governing bodies failed so far since the Pistorius case to create a framework how to deal with technological aids, in particular in the context of athletes with physical impairments. And I mean, technology will change. What will happen in 20, 30, 40 years when technological aids might be implemented in the human body when biological material or biomaterials change and have a higher potential than maybe our biological materials. Why cannot artificial tendons be more powerful than our biological tendons? And how do governing bodies deal with that? And this is near future, it's not science fiction. From my perspective, the best solution is to include Paralympians with suitable performance levels in particular events of able-bodied athletes, but on different scoreboards. Let them compete together, but rank their performances on different scoreboards. And this is not my idea. That is what Markus Rehm, the world best long jumper from one prosthesis, that's what Markus Rehm states for years already. That's what he wants. And latest, since he understood from our data that he jumps on a completely different movement principle than athletes without impairments. And I think that's a very fair, very sporty suggestion. Thank you.
Well, thank you very much, Wolfgang. And now maybe returning to Roger. And before giving you the word, I wanted to allude to your Twitter thread when you were responding to the publication of the award. And you mentioned in the conclusion of that thread, Roger, make no mistake, IAAF lost this case, which is obviously counterintuitive. Previously shut tight, the Olympic door is now open to other athletes who run on prosthesis. And yeah, I thought that maybe you would want to come back to that conclusion a little bit in your comments as well. Roger, the floor is yours.
Thank you, Antoine, and congrats to both you and Marjolaine on the launch of this new series. I'm going to be an avid participant and fan. Wolfgang, it's great to meet you virtually, and I'm long been aware of your work, and I agree with a lot of what you said. Let me say that I met Blake Leeper last year when Alina Grabowski was doing research on him. Alina is a colleague here at the University of Colorado, which you can see behind me. This is the, let me just see if I can make this happen. Right here is the high school where the track was, where Blake Leeper ran. I met Blake right before my son's soccer game at Boulder High School. Alina Grabowski's laboratory, where she studied Blake, is just over my ear here behind me. I haven't spoken to Alina Grabowski since the Cass Award, so I don't know what her views of that are. But I just want to make a few comments today about the case and its broader policy and legal significance. I think Marjolaine gave a fantastic overview. I think it's really significant that the case resulted in the reversal of the burden of proof. The placing the burden of proof upon the athlete to prove a negative was, in practical terms, a ban on Paralympians performing in the Olympics. This was recognized by CAS. There are practical reasons why this is a ban, because it requires athletes to marshal an international team of researchers to conduct fundamentally new research. But there's also theoretical reasons why proving a negative is a very difficult proposition in science. I see this case, much like the Semenya case, involving how we value inclusiveness in elite sport. And I just want to say, from that standpoint, we do not have to rely on sports organizations to define what inclusiveness means. This is a really important topic in society at large. And we can look to the United Nations Convention on Rights of Persons with Disabilities, which has an explicit discussion of the participation of what they call persons with disabilities in elite sport. And that convention, which is widely signed onto by countries around the world, including countries that are homes to the international federations and the IOC, is very clear that inclusion in an elite sport of persons with disabilities is a valued outcome. So in the United States, there's a famous court case that talks about education and the idea of separate but equal opportunities for people with different characteristics. The UN Convention completely rejects the idea of separate but equal. And what it does say, it has a very important term, concept in there that says that for inclusion to occur, we have to make what they call reasonable accommodations to allow persons with disabilities to participate in mainstream events. And so with that as the basis, that inclusion is indeed a widely shared value that's been signed on to by governments around the world. I want to talk just briefly about what that might imply for IAAF and sport in general. Under the UN Convention, it talks about equity. It doesn't talk about equality of competition. It doesn't say everyone has to have the same genetics or mechanics. And we can take a look at how the IAAF has treated shoes. As most everyone here will know, Nike with the Vaporfly has come out with shoes that by all indications, and again, more research done over my shoulder here at the University of Colorado, conveys a performance advantage to athletes who wear those shoes that athletes who don't wear those shoes don't benefit from. The difference between shoes and prostheses is just technological. They are both devices that we put on the end of our legs. Some legs are amputated and some legs aren't. And the fact that these are very similar technologies is reflected in the IAAF rulebook, where the governance of shoes and prostheses fall under the same rule. I won't go into a lot of detail on that, Shoes were first regulated in elite sport in 1957 in the high jump, when a Russian athlete stacked the bottom of his shoe with a 25 centimeter or some large buffer that allowed him to jump higher. So there's a long history here. The idea that we would regulate technology, make reasonable accommodations, is not strange, different, new. We do it with respect to drugs, with therapeutic use exemptions. And the entire competition space of the Paralympics is about making judgments about things like technology to allow and include people in different events. So there's no theoretical or practical objective to coming up with a reasonable accommodation standard for athletes who run on prostheses to participate in mainstream events. Not at all. Now, the IAAF has, and unfortunately, and this was discussed both in the Oscar Pistorius judgment and in the Blake Leeper judgment, has focused on criteria of exclusion, not on criteria of inclusion. And this was revealed in the Leeper judgment, where the CAS, and for CAS, it was pretty a strong statement. IAAF invoked what's called the precautionary principle. The precautionary principle comes from environmental science. It's something I've studied extensively, probably. It's focused on regulating pollutants. And the IAAF's invocation of the precautionary principle, and was explicitly said, any uncertainty in the science should lead to a judgment against the athlete. This equates athletes who run on prostheses to pollutants. It was an unfortunate analogy, and I think it was one that CAS seized upon when they reversed the burden of proof. So let me conclude by saying we're at a situation now where uncertainty will be resolved in favor of the athlete. What this means is that it is incumbent upon IAAF now to develop criteria for inclusion. Not what does it mean for you not to be able to participate, but what does an athlete need to do in order to secure that participation? And as Wolfgang notes, that will involve criteria of science, of course, but more than science. It will involve law, policy, values. It will be imperfect. It will be negotiated. It will change over time as technology changes. What is a reasonable accommodation? And all we have to do is look to drugs and the Paralympics to see that these criteria of inclusion are contested. They're fought over, and we reach a negotiated settlement. But where we are at now is that the IAAF is much more aligned with the UN Convention of Rights of Persons with Disabilities. And this is a positive. So as Antoine said, in my view, the IAAF lost the case from the standpoint of their longstanding expressed desire to ban athletes who run on prostheses. But in the end, I think IAAF and athletes and really anyone who enjoys sports has won in this case, because it opens the door to a much more inclusive sport at the elite level, where we can see athletes cross over from the Paralympics to the Olympics. Thank you.
Before I take, we have right now one question. I'm not sure whether more in the audience would like to send a few questions through the chat box. Maybe I wanted to give Marjolaine the opportunity to react to the two statements of Wolfgang and Roger before taking the first question that we have.
Yeah, I think I've spoken sufficiently already. I think the question we have in the chat is a really interesting one. But I have maybe just one question to Wolfgang, or maybe also to Roger, which is what do we do now with this test, the way the CAS panel defined it? So this comparison with this fictional self of the athlete. Let's say the IAAF comes to you and say you have to test the athlete against this benchmark. how would you try to solve that empirically?
I mean, a scientific study by nature will never answer all questions. I mean, science works differently. Science works by doing studies for a given research question, that will be answered partly, and other questions pop up. And science by nature is a circular process where at the end is not necessarily a proof, because we're doing empirical science, and we usually can make deductive conclusions. We have to do inductive conclusions. And then we will usually not be able to prove a hypothesis. Only mathematicians can do that. So we will never be comprehensive, but nevertheless, we will be able, and Roger mentioned that, we will be able to support the best decisions. And maybe there are some studies which give very strong indications what the right decision is, and other studies give less strong indications what a right decision is. So honestly, I don't think this suggestion is a solution, that we kind of try to do a classical experiment where we change the independent variable prosthesis or lag condition by an artificial, it would be an orthesis then, not a prosthesis. A prosthesis is replacing something. That could give additional information for the decision makers, but it will not solve the problem in general. So it is a very interesting approach. I mean, it's a straightforward idea, and my co-workers, Johannes Funken, Steffen Willwacher, Ralf Müller, in those years, we discussed that 10 years ago already, how that's possible and how much information we would gain from it. But I don't think that that would be the solution.
Roger, do you want to add something?
No, I think that was an excellent answer. If you'd like, I'd be happy to take on the question in the question box.
Yeah, go ahead.
Yeah, I think it's really important. And I think this is where
maybe maybe you have to quote. I'm not sure the attendees don't see the question, so maybe I can read the question and then you can answer it. So the question is, what does it say for the Paralympic Games if athletes using a prosthesis want to compete in the Olympic Games? Is it not an elite competition where the best athletes compete? So referring to the Paralympic Games.
Yeah, this is a question that comes up a lot of time. It also comes up in the context of female and male competition. And this is one where I think the lawyers in the audience, those who focus on institutions, recognize that there's no overarching essentialist answer to these sorts of questions. We have to rely on institutions, we have to rely on laws, we have to rely on policies. And in this regard, we can be guided by the UN Convention that I mentioned, that establishes a framework, a language, an approach to the rights of persons with disabilities. Anyone can agree with that, disagree with that convention if they want to, but it has very legitimate and authoritative standing. And the way I would encourage people to think about it, it's the same way that I talk about male and female competition. Competitions are not a hierarchy. Right? I often hear in male and female competition that male competition is up here and female is below it. And that's just not accurate. The Paralympics are indeed elite sport, but it's not a hierarchy where you have the Paralympics here and then you have the Olympics above it. They are a parallel set of competitions, and under the UN Convention, the reason we have competitions like the Paralympics is to expand opportunity. But at the same time that we have these separate categories, there's also a legal and policy commitment to inclusion of those who would participate in the Paralympics in the Olympics. Now, nations could renegotiate the convention and say we want to keep people with disabilities out of the Olympics, but that's not the commitment that's been made. So this is similar if you look within the Paralympics. If you look within the Paralympics, there are competition categories. They're not a hierarchy of better and worse, they're just different. So I think it's really important to recognize that there's no devaluing of the Paralympics if an athlete who might otherwise participate there decides they want to participate in mainstream sport. That is the entire purpose of the inclusiveness language in the UN Convention. And it's the same thing that we see across society, whether it's in education, whether it's in politics, whether it's in corporate boards. The values that we hold are about inclusiveness, not separate activities for different classes of people.
Yes, Wolfgang, please go ahead.
That's an interesting point, Roger. Really interesting, and I would like to relate that to your idea of criteria for inclusion. What governing bodies should work on. I mean, when we did the study on, when I was still just a young, no, I wasn't young, but an early postdoc, when we worked on the Pistorius case, what I said afterwards to in every TV interview everywhere is that's just the start. We have to think about how to deal with that in the future. And then the Marcus Rehm case was already on the horizon 2 years before Rio, and we said, hey, German Athletics Federation, you have to think about how to deal with that. And they didn't, and IAAF didn't. And so I really like the idea to develop criteria for inclusion. What I see is a little bit of a problem, of course, that elite sports per se is not inclusive. It's exclusive. Only the best. You only see the best. You only see the high performers. You only see the sexy people. And what we tend to forget is that in Paralympics, and you said that very nicely, Robert, it's parallel. It's not a hierarchical. It's a financial, but not a hierarchical difference between Olympics and Paralympics. What we forget is those athletes who are not that much on the scoreboard, like Oscar Pistorius or Marcus Rehm or Blake Leeper now. The guys who are doing boccia and sitting in wheelchairs and are not that sexy at the moment. Sorry for saying it like that. We have to be careful not to exclude them even more by focusing on those much more prominent people. So the point is, elite sports can be very exclusive per se.
Marjolaine, you wanted to add something?
No, I just wanted to conclude by saying it's in the end what you show is that it's not a question that relates only to disability in sport. It's a more general question on what are the equal opportunities, and on the other hand you have to be inclusive, but sport is about trying to beat the other. So you have to distinguish between where we need to be equal and where we have to distinguish ourselves in order to be better than the equal, than the other, sorry. And so that goes beyond the question of disability, and it points at all the infrastructures, genetic inequality, inequality of resources, etc. But I see we have other questions, so maybe Antoine, you can.
Yes, I think there's a follow-up, so I will pick the follow-up, and then there's another question in the chat. We have this double system that is a bit complicated to navigate. So the follow-up from Stephen, who asked the question, the original question is, if there is not a hierarchy, why do they want the crossover? I have heard Blake Leeper and Pistorius in the past say they want to compete against the best. Well, and I think here we're coming back to, isn't there a hierarchy, or isn't there some type of hierarchy that is connected at least to, for example, financial economic returns, obviously, from participating in the Olympics versus participating in the Paralympics. But maybe Roger and Wolfgang, you want to follow up on the follow-up.
Yeah, I mean, there's a very long history of segregation amongst humans in different countries. Everyone knows about experiences in South Africa, in the United States. And I'll just use the United States as an example. These sorts of arguments were made when Black children were placed into one set of schools and white children were placed in another set of schools. And the question was, why are the Black children complaining if it's separate but equal? It's just that society at large, and again, as reflected by the UN Convention, has decided that inclusiveness and integration of peoples around the world is a valued outcome. So if Blake Leeper and Oscar Pistorius say, I wish to run with what are called able-bodied athletes, then it's incumbent upon all of us to then figure out, well, then how do we achieve that goal? It's going to be imperfect. People fight over it. But honestly, if an athlete has a chemical imbalance in their body and they need medication that otherwise would be prohibited by WADA, we have criteria of inclusiveness for those athletes to have a therapeutic use exemption. If a skier blows out her knee while skiing and needs it to be surgically repaired, we have criteria of inclusiveness to use our advanced technology to get that athlete back into the competition. When an athlete tears their ACL, we don't say, okay, now you're in the Paralympics. No, we say, all right, here's what you need to do to be included back. So I have little time or attention to arguments that say that we should be putting people in separate categories and then make them a hierarchy. It's just, that's not where the world is in the 21st century.
And Wolfgang, do you want to add something? Or?
No, in principle, as I already said, I like the statement criteria for inclusion. And of course, this is a starting then an interesting and probably getting emotional discussion then. What is the limit? So my point probably would be if we, from a biomechanical perspective, see two different movements, then I would ask the question, well, do I really want to compare them in one scoreboard, right? And if these different not movement techniques, but movement principles, physical principles, have different performance limiting factors. Like my example is always long jump. Usually if a normal long jump, sorry for saying normal, it's not normal, for an elite long jumper, if he increases just his normal running speed, his usual running speed, he would not jump further. We didn't investigate that, but the data we have at the moment allow the assumption that a long jumper from a prosthesis, a prosthetic long jumper, who would increase his run-up speed, probably jumps further because he can store more energy in the prosthesis and then jump further. And these performance criteria, these performance limiting factors are different. They are really different, and what makes one jumper jump further using the other principle would not make him jump further. And even more important, Johannes Funken figured that out in his PhD work or elaborated that in his PhD work very nicely. They cannot change from one movement principle to the other. If you jump with a prosthesis, you cannot change to the other movement principle. If you don't have a prosthesis, you cannot change to the other movement principle. And I personally, that's my personal opinion, would have difficulties to have these two really fundamentally different movement and performance principles in one competition on the same scoreboard. That's my personal point of view, and I think it's logic.
Let's pick up. We have so one question in the chat, more for, I would say, a lawyer, but Sergey asked, it says, it appears that World Athletics and other sporting federations will try to escape from the effect of the mentioned UN convention. Do you agree? If so, how can we ensure that World Athletics and other sporting federations comply with the UN convention? Maybe this is something for you, Marjolaine. You want to pick up on that? Or?
Yeah, sorry again. I can say some. It is certainly in part, of course, a legal question. So I'll try to give my answer or have a try. It is a very difficult question. It was raised in the CAS award. We didn't insist on those aspects, or I didn't insist on them in the introduction. But there was the issue of whether the IAAF was bound by the convention, and this is an issue that we have with all conventions, that we have with the ECHR, the European Convention on Human Rights alike, is that sports federations are organized as entities under private law, so frequently as associations of Swiss law. Now, World Athletics happens to be in Monaco, but the principle is the same. And conventions are instruments of international public law, so that only state parties are directly bound by these conventions. And at least in Switzerland, in Swiss law, we do not recognize what is called the horizontal effect of fundamental rights, at least not as a general principle, in that human rights instruments do not apply directly in between private entities or individuals. So it is a very difficult issue to know, which I think Antoine is aware, familiar with in around corporate law and business law. The fact that you have private entities that almost have the status of a state, but are not bound and cannot be bound with the current instruments to these international public law conventions. So that's what I can say about this.
Yeah, Roger, you want to add?
Yeah, I mean, I agree, obviously, with Marjolaine on that, but there's a few other details. I mean, the UN Convention on the Rights of Persons with Disabilities has an explicit section that speaks about reasonable accommodation in elite sport. So it is there's no ambiguity there. And when Ban Ki-moon announced that convention, he was explicit about the relationship of the Paralympics and the Olympics. But as we've seen with IAAF says they follow the Helsinki principles on medical and research ethics. And as we saw in the Semenya case, that adherence is deemed to be optional when they decide they don't want to follow it. And so something to watch will be the upcoming Semenya case, I gather, at the ECHR over whether the IAAF is indeed bound by the provisions of human rights instruments. The president of CAS, John Coates, has said publicly, absolutely, we should be bound by the ECHR. Both in the Semenya ruling and in the Leeper ruling, the IAAF has contradicted that and said, no, as Marjolaine said, we are a private entity and we don't have to follow these rules. And as so often happens, it's going to be up to courts to decide what laws are followed by whom. And in this case, I think this is one where the legal processes will have to play out.
If I may add on that debate, because it's also a debate where I'm more on familiar ground actually than the previous discussion that we had. I mean, I think here we are really dealing with an important issue in sports, which is that we have governance that that is exercised by formally private parties, private associations. And that is a contradiction in itself, that sports law, sports governance is constantly grappling with, and is as well reflected in that discussion of the applicability of human rights and international conventions to sports governing bodies. There are many, I think the current situation is much more nuanced than this is inapplicable or this is applicable. You see it actually in the Leeper case, but you see it in other cases where the CAS is going to integrate certain elements taken from the European Convention of Human Rights or other international conventions and read them into certain provisions that are integrated in the statutes of sports governing bodies, such as references to non-discrimination, for example. So here you see already a form of horizontal effect that is happening through the back door of their statutes of the sports governing bodies. The same is true nowadays. The statute of FIFA includes a clear reference that FIFA is complying with internationally recognized human rights in its Article 3. And this is an open door to basically say that FIFA has to comply with international conventions that relate to human rights. So again, this is not a black and white issue. This is much more gray. You have also the role of the ECHR and of the review of the Swiss Federal Tribunal. Depending on the decision of the ECHR in Semenya, you might see a much stricter review on the basis of public policy at the Swiss Federal Tribunal level on the basis of rights derived from the ECHR. So you see, this is a very important and moving debate right now in sports law, and it's not, let's say, defined yet, and it's very much subject to a lot of debates in scholarship, but also before a number of courts. Marjolaine, you wanted to add something? Or?
Yeah, I just wanted to add something in the same sense that it is a matter with graduations, and because Roger mentioned what the CAS said about the issue, and I think there are two different issues there too, is whether the international federations are bound by the ECHR and whether CAS as an arbitral tribunal has to provide judicial access that is in compliance with in particular Article 6 of the ECHR. So I think it's becoming it isn't really controversial anymore that CAS panels have to provide a process, or let's say the Swiss judicial system as a whole, CAS and Swiss Supreme Court have to provide a process that is compliant with the guarantees of judicial access under the ECHR. It's a different question to say, let's say for a different article of the ECHR, like private sphere, that a private body like the IAAF is directly bound by the provisions on the respect of physical integrity or private sphere that are in the ECHR. But as Antoine says, these are matters that are certainly evolving.
We have to pick up a number of questions that have popped up in the chat. And first, there's Johannes Funken. I think Wolfgang was talking about Johannes earlier. That has a question that is directed to Roger. And his point is, maybe right now 400-meter runners or long jumpers might be on the same performance levels between, I think, disabled and able athletes, I think he means, with and without amputation. If we now allow athletes to compete in the same category, what should happen if prosthetics or movement strategy evolve and then provide an advantage to, I guess, the disabled athletes? We cannot say now that you are much better, you cannot take part anymore or compete in the same category. What do you think, Roger?
Yeah, I mean, this is the uncomfortable, messy reality is that we already do this. So the WADA code and the prohibited list are updated every year, every few years in the case of the WADA code, and reflects that we learn about new drugs. New drugs are invented. Athletes are clever. They come up with new applications. Things that were once allowed today are banned. Things that were previously banned are now allowed. The reality is we already govern technology in sport very well. The more important issue, and I want to follow up just real quickly on what Marjolaine said. I mean, this whole process with CAS and the idea of burden of proof, to me, reflects one of the greatest weaknesses in sports governance, and that's the lack of a precedental basis for CAS decisions. So for some reason, we believe that the burden of proof has been reversed, not just in this case, but in general. However, in the Semenya case, the previous Duty Chand ruling was not determined to be a precedent. So there's no such thing as a international body of sports law, in my opinion, that has anything resembling a jurisprudence. It is unfortunately case by case, except when we decide that it's not case by case and it's general. And in this case, we have a general precedent. And I, as an observer, don't know which CAS decisions are deemed precedental and which ones are deemed one-off for the case. And that's a problem, relying on arbitration as the basis for these sort of decisions.
Marjolaine, you want to pick up on that?
I really just wanted to ask Wolfgang, for maybe from a more like bioethical perspective, what he thought about the question in the chat. So what should we do once the technology has progressed, so that we can really say that it's more efficient to be an amputee than an able-bodied athlete?
That is, well, I think it would be unfortunate if we really have to go in testing prostheses all the time and checking if they are allowed or not. Not even in Paralympic sport that happens. They just look for the if there are actuators in, or if the standing height is okay, and so on. I think Johannes' point is more, if we say now, based on whatever criteria, we include runners with the prosthesis, because at the moment we think there is no advantage. They don't provide advantage. And one thing is, if the technology would change, okay, then we could find a certain regulations say defining the criteria for the technology. But I think Johannes' point is also, if the movement technique would change, and all of a sudden the athlete changes the movement technique and all of a sudden is able to create an advantage, what do we do then? And that's from my point of view a very interesting thought. I never thought about that. Then you cannot, from my point of view, it would be very unethical, but I'm maybe very naive in that sense, just a biomechanist. So it would be unethical to say, oh, now you're better. Your movement technique changed. You cannot use that. I think that would be a very unfortunate situation, especially for the governing bodies, not only for the athlete.
Roger, would you like to react? Yeah.
Yeah, let me just say, I mean, in a hypothetical world, we could imagine in the future where if athletes determine they can get an advantage through running on prostheses, that athletes would willingly choose to have their legs amputated and then run on prostheses. And if you think that's far-fetched, in my book, I talk about mixed martial arts, where athletes have willingly undergone surgery. This is kind of gross, where they pull back the skin on their face and they sand down the pointy parts of their bones. They do this so that when they get punched, they don't bleed, because the human skin is such that if you start bleeding a lot from a lot of fights, then you become a bleeder. So athletes have already shown their willingness to alter their body, not just through drugs, in order to gain an advantage in sport. So, you know, if I took Wolfgang and Alina Grabowski, some bioethicists, some federation officials, and locked them in a room, and said, come up with some criteria of inclusion, it would be a really difficult job. And it would be imperfect and people would argue about it. But I think it's necessary. Those criteria can be highly restrictive. They could provide a small window for athletes to participate, but the key is there has to be that window and it has to be realistic. It cannot be, in effect, a ban. So I'm not, I wouldn't envy experts like Wolfgang having to contribute to that, but it's no more difficult than what we do all of the time with illegal drugs in sport.
Yeah, we have a question or remark in the chat about this, about how far should inclusion go? An athlete with cerebral palsy, if they want to compete in the Olympics, should accommodations be made for them to try and qualify? So I think that is what you both just said, is that at some point we will have to make calls and decide who is on the side of on which side of the fence, in a way, which is a pity. It's the same debate that we're having with the athletes with differences in sex developments and Semenya Castro. At some point, there is always a certain unfairness for someone. So we are trying to minimize the unfairness overall and for each individual, in a way. And then there is no ideal solution. Antoine?
Yes, I mean, we have at least 2 other questions, so I'm not sure whether we are going to be able to take them all, but I would like to raise the one that is in the box, in the Q&A box, by Surby Kuvelka. And is future classification as followed by the IPC the model to follow in the future for able-bodied athletes, as opposed to the other way around, categories based on impairment, irrespective of traditional gender binary, given that arguably a binary is no more defendable with evolving science as well, whether or not that is done away with? This is from a merely practical perspective, irrespective of current legal challenges to the existing system, and has any thought been given to that? What do you think about that? Maybe Roger and Wolfgang.
Yeah, I'll just quickly say that, I mean, it's a good question and we won't have time to answer it here, but I would say that if we reorient our thinking about this issue from what are the criteria of exclusion to what are the criteria of inclusion, we're going to be forced to confront this question and come up with answers to it. There's another question: how far should inclusion go? The language of the UN Convention doesn't talk about accommodations; it talks about reasonable accommodations. And in policy and law, we use imprecise terms like reasonable, subject to being negotiated as part of a regulatory process. So what is a reasonable accommodation for Marcus Rem is going to be vastly different, obviously, than for someone with cerebral palsy, as you say. And lines have to be drawn somewhere. So I agree, it's a difficult and thorny issue, but we're smart. We're caring people. I think we can come up with what are reasonable accommodations in a much more inclusive way than we presently do. That's the standard I would apply.
Maybe Wolfgang, would you like to react as well?
Well, that's a little bit beyond my expertise, of course, being a biomechanist. I'm always referring to that. Mechanics is simple, well, no, but in that sense, simpler. When we did the Pistorius study, even before the CAS meeting, we discussed this issue on this standing at the bar and having a drink together level. And what I always said is, in the future, well, not the near future, we actually need joint events, that there is no real distinction between Paralympics and Olympics anymore. That we would have one kind of event, which is called whatever, and you have a 100-meter race, 200-meter race, A, and you have a 200-meter race B, which is not hierarchically, it's not higher or lower level. 100 meters for men is not higher or lower than 100 meters for women now. And in type A, there are certain technologies allowed, and in type B, those technologies are not allowed. That could be a scenario. I mean, it's something which doesn't really sound familiar to us now. But again, in 50 years, there will be technologies which are inside the body, which are not visible. And we have to deal, or we in 50 years not, but our kids have to deal with that, or our grandkids. And again, parts of it is reality already. Roger mentioned this creepy scenario of the kind of surgery you mentioned. Others are present as well. If I'm not mistaken, in baseball pitchers, it's not unusual to get a surgery on a healthy body here to increase the insertion side of the tendon to reduce mechanical stress to prevent from injuries. We at the moment probably say, well, that's it's weird, but it's kind of natural. It's not doping or it's not unfair. They do it. But how do we talk about that if this is an artificial material, or if I let biological material be 3D printed, that's existing, it's not science fiction, and this is more powerful than our biological material. And I say, well, I want a new Achilles tendon, which makes me faster. And that is the case. A better Achilles tendon and a better quadriceps tendon can make you faster or move more economic. That is the case. And then I don't know if we need Olympics in 100 years and Paralympics, or if we have something like joint events with different categories in different races.
Marjolaine, go ahead.
Do we have time to? There was another question that was a more legal one. Do we have time to? I mean, I can be here till midnight if you'd like.
Well, we have until 5:30 max. So
Okay. Well,
still take one.
no, so we'll take this. There is a question that is more around the reasoning of the CAS. So I'll try to say a word about this. So the question is, what is the legal ground of the tribunal's choice about reasoning? And why do they ask some questions and not others? For example, does the rule pursue a legitimate objective, and is it necessary, reasonable, and proportionate? And what will be a legitimate objective? So that there are maybe two issues that I can raise. The first is that specifically the dispute in this case was around the fairness of the burden of proof. So the panel did not really look into the other aspects of the rules, but they looked at whether placing the burden of proof on the athlete, this part of the rule, was necessary, reasonable, and proportionate in a way. And they decided it was not, given the burden on the athlete, and for various reasons, both practical and related to the technical issues around having the burden of proof. And then, does it pursue a legitimate objective? This was, I didn't discuss that in the intro, but it was actually, it wasn't a big point in the award, but I think it was actually discussed. So the IAAF had to argue that the rule was actually aimed at protecting the integrity of sport, because there was a sort of suspicion that the rule was actually only aimed at excluding disabled athletes from sport. And so there was a discussion by the CAS panel around that, and in the end, they, I think not by very much, but they recognized that on balance, it was pursuing the objective of integrity of competition. So there was some form of assessment. But it's true to say there wasn't a real overall, maybe Roger will want to react also on that, there wasn't an overall sort of assessment of proportionality of the rule in this context.
Yeah, I would just say I agree with that. And the fact that the prosthesis rule is wrapped up with the shoe rule And these rules, I have a table and a draft paper. These rules have changed almost every year since Pistorius. It's a very much a moving target, and it's very difficult, I think. I mean, it's difficult for casts, it's difficult for athletes. There does need, you know, to get to the basis of this question, there does need, in my opinion, to be a firmer, more permanent legal ground for this issue that does deal with things like advanced technology, shoes, prostheses, artificial Achilles tendons, Tommy John surgery, and so on. This is where sport is going, and we're just at the very beginning of this issue, I think.
Maybe I want to pick a little bit on that, because we haven't really touched upon the issue that much of the shift of the burden of proof, and it is a big decision. I mean, and it, to some extent, it justifies also the counterintuitive take of Roger. And I want to turn to Wolfgang, because the way I read the decision, this means that now any disabled athlete or any athlete that wants to come in, a disabled athlete that wants to come in with a prosthesis that is different than the one that was used by Blake Leeper, but that might give him anyway an edge for a variety of reasons that I don't know, but that you may know, will be able, in theory, to enter an IAAF competition unless IAAF can adduce evidence. And a bit the tragic irony of this case is that IAAF relied on the evidence that Blake Leeper had gathered himself to actually demonstrate to the panel that he had an unfair advantage. But in the future, an athlete will not have to submit himself to those tests willingly, and it could be a strategy, and here I'm thinking also from a legal practitioner's perspective, to try to apply to participate in the competition and then to push the burden. I mean, IAAF would have the burden to show that that particular prosthesis gives an unfair advantage. And that might open up a new evergreen maybe for you, Wolfgang, and your team, because you might get a lot of work in the future from the IAAF to test what is coming up.
You think we should block the laboratory already for the next couple of years? Yeah, it's a nice business model. You have to answer the question if this is really if this would be really the scenario that from a legal perspective, the athlete registers for the Olympics, and then the IAAF or the World Athletics has to change that. Yeah, our understanding was that as well, that should be possible in principle. But again, we are naive readers of those decisions and don't know the implications. Of course, the first people came and asked, "Hey, what will Markus Rehm do now? Actually, what does World Athletics do with the results of Markus Rehm? Is he now allowed to participate or not? Or how is it?" As far as I understand, Markus still says, and there's just a video. Just a video came out. He posted a couple of days ago. Inclusion would be for him to do joint events, different scoreboards. From a sport ethics perspective, I think that's a great statement. I want to participate. I want to compare myself with other great athletes, and he's jumping 1 meter further than the second best in the world, a Paralympic athlete. But I don't need your gold medal. I don't want to take the gold medal away from you as long as we don't have common ground for it. I think that's a great statement from an athlete.
Maybe I can just give the view of the CAS panel on this, because I don't think the future is necessarily that bright actually for the disabled athletes, because one of the reasons in the reasoning of the CAS panel for saying that the burden of proof was disproportionate was to say, well, in the end, you can achieve the same result by asking the athlete to cooperate in you discharging your burden, IAAF, and ask the athlete to participate in studies. And if they refuse to participate, then we as panels, we will be able to draw adverse inferences and conclude potentially that the IAAF has discharged the burden because you refused to subject yourselves to any tests. So actually, we see it as a victory for disabled athletes, but in future, I'm not sure whether they will have much more freedom and whether they might be subjected to tests that the IAAF chooses.
And you follow up quickly on that to you, Marjolaine. Do you think that they could be provisorily authorized to run until the IAAF has done the testing and has the scientific evidence? Because that could mean, for example, that you just ask to participate just prior to a big competition. The IAAF doesn't have the time to run the tests. You have provisorily the right to run. Would that be a possible scenario?
Well, probably. I don't see if it's on the IAAF to prove. I don't see how they could block an athlete prior. They would have to go in front of CAS and request provisional measures from CAS to ban the athlete. But absence any evidence, I'm not sure. It would depend on the case. Probably, if it's really obvious. I don't know if someone uses an electric wheelchair that is twice as fast as the 400-meter runner, you can imagine anything. But normally, no, the athletes should be able to compete unless and until they are blocked. Maybe Roger wants to add something.
Yeah, I'll just say, I mean, even with and Wolfgang, is the expert here, but the zone in which there's uncertainty as to advantage, it's not a small zone, it's a fairly large zone. I mean, obviously, if you have the wheelchair that goes 100 kilometers an hour, that's obvious. But if uncertainty is resolved in the direction of the athlete under the current ruling, we can imagine a scenario where the top 20, 30, 40 Paralympic athletes who run on prostheses all at the same time apply to IAAF to start running. Evaluating each one of those athletes, their particular disability, their particular technology they use, would be enormously costly. It would, Wolfgang would get a few hundred more postdocs, but this is why IAAF is now in the position of needing to develop generally applicable criteria for inclusion. The system is broken, and I do think it opens the door for disabled athletes to have greater participation, but we're just at the start of what that means. Because I would be the first to say that resolving uncertainty in favor of the athlete is an unsatisfactory outcome, because that zone of uncertainty is just so large. We need to do better than that.
Thank you, Roger. Marjolaine?
No, I was going to say, do we need to close? Are you going to close? Maybe I'll just say, thank you. I let you close, and I'll just say first, thank you really to our two guests. I hope it was really interesting for the audience. It was really interesting for me. And I think now if the audience, we raised more questions maybe than we gave answers, but maybe like if the audience gets out and over the next hours or the next days, they keep reflecting over those issues and trying to solve them for themselves, maybe we've already achieved our goal. So thank you.
I don't have much to add. I want to thank you all, thank the speakers, thank the audience, and we hope to see you again in the next in 2021 for our next edition. Probably I'm going a bit ahead of myself right now. Probably on the International Skating Union decision that is coming from the Tribunal of First Instance of the Court of Justice, but we'll see. Hopefully, it will be early January. So thank you all, and have a nice weekend.